This video is the first in a series on traffic stops, the aim of which is to help protect you from police abusing their powers and to demonstrate how you can remedy unlawful stops with civil action. I receive so many emails from people who have been subjected to police misconduct it's become almost impossible for me to respond. For this reason, I've decided to begin uploading videos that cover in detail the most common complaints. In each case, I will give my opinion as to where and why the police's actions are unlawful and set this against all the relevant laws, precedents and regulations to show you how I reached that conclusion. In my opinion, the police complaints process is unfit for purpose, and the only way you can truly hold them to account is by bringing a civil action against them where one exists. Not every instance of police misbehaviour results in a civil claim. Less than half of all those who contact me have valid claims, and those that don't have a hard time accepting this fact. You cannot sue the police just because you don't like the way they treated you. The courts have established a narrow set of tools that provides claimants with remedies against the vast array of potential police misconduct. You cannot invent your own. If you don't agree with my opinion, then don't let that stop you from pursuing a claim if you are so determined. If you do agree with my opinion, then don't blame me if you pursue a claim and it doesn't succeed. The final determination will ultimately rest with a judge, and if they were always right, there'd be no need for appeal courts. But if you pursue your claim respectfully and diligently, then it's more likely than not it will settle without ever needing to set foot in court. I'll focus on the mechanics of legal action in future videos, but for now, this series is designed to help you establish whether or not you have a claim. Also, by understanding your rights and the limits of police powers, you may be able to protect yourself from misconduct and wrongful prosecution. Vehicle stops are the most common instance of the public encountering the police, which is why I've chosen to start with this subject. So, let's begin.
Police are here, what the hell?
Knock the engine off.
What's
Knock
up?
the engine off, please.
Alright, what's up?
Chuck that out. Knock the engine off. Chuck your key out.
Why would I chuck the key out?
Just put the key out on the dash free.
Why, what's wrong? I'm not going to drive off.
You're driving around with a balaclava on and sunglasses in the dark.
It's not a balaclava, it's a...
You're still covering your face up.
Right.
Is that illegal though?
Right, just bob your keys on the dash.
You're going to grab them though, they're my keys.
We won't grab your keys, we're just asking you to put them on the dash.
Can you believe this, guys?
Yeah, if there's any other unit in the Normanton area, could they just join us at Sillingdale, please? Just one more unit, please.
Oh yeah.
Right. What's going on?
I don't know, what is going on? Why are you at my house?
Right. Why? Because do you not see that there's something a bit bizarre about driving around in sunglasses and a face covering?
I like to be bizarre, man. Is there a problem with that?
No, there's no problem with being bizarre anyway. Right, so unlock the car for me.
Why though?
Okay, right, given what's been going on, right, I'm going to give you a section 1 search under pace, okay? Right, so jump out the car. Alright.
But I've done nothing illegal though.
No, I'm not saying you have done, but I'm detaining you for a search under pace, alright? Okay? So, open the car, pal.
I'm not your pal.
Unlock
buddy.
the car.
Pretty sure I don't have to unlock the car, mate.
Say again?
I'm pretty sure I don't have to unlock the car, mate.
No, you do, because I'm detaining you for a search under section 1 of pace.
But what have I done wrong? What do you suspect me of? What crime do you suspect me of committing? You have to suspect me of committing a crime before you can search me.
Yeah, I suspect that given the way that you're dressed, you're out going and committing burglary.
Why though? What gives you the power to just randomly search me just because you don't like the way I'm dressed? That's a bit weird, don't you think? I don't like the way you're dressed. Can I search you?
You're not an officer. You don't have the powers of an officer to do that.
Okay, well, if I become a police and I just don't like the way someone's dressed, does that mean I can just search them randomly? Does that sound right to you? It doesn't, does it?
Where are they?
I mean, you've got my address and everything, so if I was going to commit a burglary, you know, it'd be a bit stupid, don't you think?
They're on the way from Normanton now.
Class. Right, are you going to get out?
I mean, what are you going to do if I don't get out? You're gonna force the car open?
Yeah,
or?
yeah, we will do.
Yeah, we will, yeah.
Guess I have no choice then. I'll get out then. I don't want to get my car searched. Shit, dude.
Right, jump out the car for me, pal. Right, show me your keys. Show me your keys.
Give us your keys.
Show me
I'll
your
keep
keys.
them in my pocket,
No,
mate.
No, give
I
us your
don't
keys.
consent to any
Right.
seizures.
Say again, you don't have to consent. Right.
Right.
Okay, in
Stand
order to do
there,
this, right, get your hands out your pocket. Okay, right, I'm just going to cuff you in order to search you.
Okay,
Alright.
okay. Yeah, you can cuff me, mate. I don't have a problem with that.
So to recap, the two officers have followed the driver all the way to his home without initiating any stop. The driver parked up and only then did they approach his window. Therefore, this is not a stop under Section 163 of the Road Traffic Act, nor do the police mention it as such. Now, I'm going to presume this occurred on a public street rather than a driveway, otherwise you could add trespass to the list of wrongs, which is extensive enough already considering the two officers didn't do a single thing right. They approached the driver solely to question him on his appearance, and it's clear he's not free to leave until he's satisfied the police he isn't up to no good. But the police do not have any powers to detain a person in a vehicle or on foot simply to ask questions. Nor do they have powers to conduct a vehicle or person search simply to reassure themselves that person has not broken the law. As the driver's appearance is the only thing that's aroused the officer's suspicion, this renders the subsequent search as unlawful. This is because, to justify a search under Section 1 of PACE, the officer must firstly have formed a subjective reasonable suspicion that he will find stolen or prohibited articles. Secondly, the suspicion that such an object will be found must appear reasonable to a hypothetical bystander. This is the objective test. Would a reasonable person come to the same conclusion that the driver is likely to be a burglar based solely on his appearance? That's without taking into account police codes of practice, which make it clear that stop and search should not be conducted solely on the basis of a person's appearance. But we can go further than that, because even if the officer did have the requisite reasonable suspicion, and that wearing a mask in the middle of a pandemic is suspicious, the search would still be unlawful. Why? Because the officer conducted the search defectively and failed to provide the driver with information he is obliged to receive. Stop and search is one of the few police powers that automatically give rise to a civil claim if the searching officer fails to abide by its strict statutory procedures as set out in Section 2 of the Police and Criminal Evidence Act. If a constable contemplates a search other than the search of an unattended vehicle, it should be his duty to take reasonable steps before he commences the search to bring to the attention of the appropriate person A. the constable's name and the name of the police station to which he is attached, B. the object of the proposed search, and C. the constable's grounds for proposing to make it. This information is mandatory. The detainee is not required to ask for it, nor even be aware that he is entitled to receive it. Any failure by the officer to provide the information before commencing the search renders the search unlawful. The respective false then becomes liable for assault, battery, false imprisonment, and in the case of vehicle searches, trespass. This is supported by the PACE codes of practice and a variety of different precedents, most notably the judicial review of Michaels in 2009, which affirmed the failure to identify name and station renders the subsequent search unlawful. It's fortunate that the driver insisted on recording the encounter because, had he not, the police would almost certainly have denied that the search was defective. This is why it is essential you record the police during any encounter you have with them. A claim or complaint with video evidence is much more likely to succeed than one without. Next, I want to focus on the police's automatic use of handcuffs. Is there anything wrong with the police automatically restraining the driver for the purposes of a search? Well, surprisingly, there are no laws or regulations surrounding police use of handcuffs. Their use falls under powers of reasonable force provided by Section 117 of the Police and Criminal Evidence Act and Section 3 of the Criminal Law Act, as well as at common law, breach of the peace and self-defence, all of which establish that any force used must be reasonable in the circumstances. Unfortunately, British police have developed a custom of handcuffing almost everyone without considering whether the force is necessary or reasonable. The police justify this by saying that indiscriminate handcuffing limits potential risk to themselves, but there is no blanket exemption from reasonable force. An officer may believe he has the right to treat every suspect as the very worst kind to limit risk to himself, but in so doing, he's dismissing the detainee's right not to be subjected to unreasonable force. And in any event, the test of what is reasonable force in law is both subjective and objective. Just because the officer believes handcuffs to be subjectively necessary does not make it objectively reasonable. Indiscriminate cuffing of passive subjects potentially gives rise to a vast number of lawsuits for battery, not taking into account the public humiliation and mental suffering associated with it. Handcuffing may be commonplace to an officer who sees it every day, But to a member of the public who may be encountering it for the first time, it can be humiliating and degrading. For this reason, it engages Article 3 of the European Convention on Human Rights, which is the prohibition of inhumane or degrading treatment or punishment. The College of Policing insists that handcuffs must only be used when the officer believes the person to be a flight or threat risk. The severity of the offence must also be taken into account. In this instance, not only is the offence non-existent, the driver is calm, shows no sign of physical resistance, his car keys have been confiscated, the officer has a colleague for backup and has radioed in for yet more backup. Even if the search had been lawful, the use of handcuffs in this instance was clearly unreasonable. It's just unfortunate that the detainee chose to say he didn't mind being cuffed, because this would be used in the police's defence against a claim for battery. The driver's words could easily be misconstrued as a tacit consent. Not that it matters much, because the mere fact that the search was unlawful automatically renders any force used to conduct that search unlawful and is therefore a battery. In this instance, taken along with all the other wrongs committed by the police, the driver has a valid claim for the following: false imprisonment. This arises chiefly from the driver being detained for an unlawful search, but I would also say that the police's threatening manner when they ambushed the driver at his vehicle to interrogate him was also a false imprisonment. Assault. Had the driver not cooperated with the search, he almost certainly would have been searched by force or arrested, and this is where the assault is made out. I explain technical assault in more detail in the next video. Battery. Brought about by the police's physical, unlawful search and handcuffing of the driver. It's unlikely the use of handcuffs could be considered a breach of Article 3 in this instance, because the driver stated, "I don't mind being handcuffed." An example of how friendly cooperation in the face of an unlawful stop and search can actually be damaging to the claimant.